Thank the Chairman. For the other members who do want to do a second round, we will do that. And so I'll kick it off and recognize myself. And I just want to reiterate, people have mentioned the morale. And granted, a lot of the things that happened were before you were there. But I do think it's worth mentioning that there are a lot of taxpayers who have had their morale hit. When they see some of the conference spending that's gone on, $50,000 for a Star Trek parody video and other lavish expenses on their dime. And again, that was before you were there, but that really irks a lot of folks and certainly our constituents. And I think the same goes for the targeting when people feel like they were being targeted or in fact were targeted simply from exercising their constitutional rights. I think that hurts their morale too. And so I just think it's important that we mention that. Now, a lot has been going on about when you knew there was a problem, why you delayed telling Congress. And I think it is the case that the standard that would be applied to an official such as yourself is not simply what you actually knew, but what you should have known. In other words, you can't bury your head in the sand and not be apprised of what people in your organization know. And so I think that's going to be a question is, clearly, there were people at the senior leadership level in the IRS early February, mid-February, who knew that the problems were more substantial than what you indicated to us that you personally knew. So the question is going to be, why did you not know more? And I think that goes into what I and some other folks have raised, and I know my friend Mr. Cartwright disputed the notion that this is being investigated by the Justice Department. And just so we're clear, because I don't want to be lobbying charges that aren't true, here's the transcript from last week's hearing with James Cole, DOJ Deputy AG. Chairman Jordan, the fact that the Commissioner, meaning you, at the Internal Revenue Service delayed telling Congress, the American people, the FBI, and the Justice Department is a matter that you are going to investigate. Mr. Cole replied, we are going to look into what the circumstances were around that, yes. And so we're concerned about it, and the DOJ seems also to be concerned about it, and I think that that's important to know. Let me ask you this. You mentioned that you have seen the Ways and Means press release about their conducting interviews with different IRS technical witnesses about what in fact happened to the hard drive. And so they told Ways and Means that the hard drive was scratched and that data was likely recoverable from it. And of course, the IRS just last week in federal court has filed a declaration saying, consistent with I think what you've testified to, that the hard drive was destroyed and in fact no data was recoverable for it. So my question is, what's an American to think when they see some witnesses telling a congressional committee scratched may be recoverable, but yet the IRS is representing in federal court that it was destroyed and completely unrecoverable?
I wasn't there, and I haven't talked to those people, and I don't know what that interview yesterday
was. But they would, the technical people would be the ones that we would most want to talk to about that, correct?
All I know is the emails that I've testified at a couple previous hearings about show that there were efforts made by Ms. Lerner and the IT department to restore the hard drive. It went to the Criminal Investigation Division and their experts, and they said they were not able to retrieve information from that hard drive. That's all I know. That's what the emails contemporaneously at the time showed and said was that they had tried, the experts in the IRS had tried, they were unable to recover any information.
Okay, so and I read the pleadings and I take that point, but we are getting conflicting information, it seems, in the Congress at this point. So I think it's going to be important that that be resolved, because clearly you can't be telling the court one thing and then having people in the organization who are on the ground and maybe had intimate knowledge telling the Congress the other thing. I'm almost out of time, but just very quickly, switching gears a little bit, the D.C. Circuit issued an opinion about the IRS's regulation as respects to Obamacare subsidies, taxes, and mandates in the states that have exchanges not run by a state but run by the federal government. Given that right now there's a circuit split where you have the Fourth Circuit saying that basically it was either a close call or a Scrivener's error, you have the D.C. Circuit saying actually the IRS didn't have the authority to issue that ruling, are you going to rescind that rule until this can be resolved by the Supreme Court, or what's the IRS's position in light of the Halbig case?
The rule about the granting of advanced premium tax credit, all is run by HHS. We have, our regulation said that, in fact, it was appropriate and acceptable to go through the court, through the Federal marketplace. We have no plans until the issue is resolved in court to rescind or change that rule or change our preparation for the next filing season.
And is it your position as the IRS that you've construed that to be that there may have been a drafting error in the statute, but the intent of Congress was that the subsidy should go, and is that why the IRS has taken the position that they've taken?
I'm supportive of the Justice Department opinion, which was upheld in the Fourth Circuit, not upheld in the D.C. Circuit. I don't have a different view of the legality. I think the Justice Department puts it very well, that they think the statute is enforceable and the regulations are appropriate.
Okay. I am out of time, and I will now yield